Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello, lovely people. Another opportunity is here again for us to come your way with the community and the law. This afternoon, we're asking the question, is it possible to apply for settlement if you can show residence for 2.5 years out of 5 years based on EUSS updates? And by courtesy of BWF Solicitors, lawyer Eunice Champon will be on hand to help us answer that very important question. We've got some updates and, of course, some very interesting things on the program, The Community and the Law, brought to you live on BWTV, at BWF Solicitors, Facebook and YouTube, and at BWTV, both on Facebook and YouTube. My name is Oreku Frimpong. Good afternoon and welcome to the program.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live. Good afternoon once again, and a warm welcome to another edition of the Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. When it comes to giving updates in regards to immigration matters, home office updates, and all the rest of it, you can trust BWF Solicitors. And of course, this channel and this program to give you the accurate and most up to date ones. This afternoon, we're going to really look at a very pertinent question that most of you have posed, especially during this week. Is it possible to apply for settlement if you can show residence for 2.5 years out of the 5 years based on EUSS updates? This question is going to be dealt with by the partner of BWF Solicitors, and we're talking lawyer EUSS Achampong. Auntie Eunice, good afternoon, and thank you for joining us. How are you doing? I think we.
Can you hear me?
Yes, now I can hear you.
Okay, that's good.
Good. So I was
Yes,
saying good
so I'm
afternoon
doing
to you
well.
and expressing our appreciation for your time this afternoon.
Sorry, come again.
Yeah, I said I was saying good afternoon to you and expressing our appreciation for the fact that you joined us again this afternoon.
Oh, I'm grateful for obviously you hosting us and you helping us to educate the community as well. So I hope you're also doing well.
Well, I'm doing very well. And there's this question, as I've posed earlier on, and I know definitely you're so well prepared to help us through that. But before that, let me go over to some appreciation that has been expressed by some of our listeners and, of course, clients for the wonderful things BWF Solicitors is doing for the community here in the UK and even back home in Ghana. Faustina comes up to say that I am so happy to finally get a visa for my mom after two failed attempts. BWF solicitors came through for me, and by the grace of God, it's been granted. Thanks for the amazing team, especially Chelsea, for all the help and support. I would want to believe Chelsea is one of the team members in Accra. So Faustina is expressing appreciation, loyalness.
Yes, and it's good to have our clients give such reviews because when it comes to the work that we do make sure that clients are receiving the utmost satisfaction. And for her to have had two failed attempts at bringing her mother on a visit and then finally getting through with this application means a lot to her, I'm sure. And so whenever we put a smile on our clients' faces, we know that we've done the best that we could in solving their problems for them. So, yes, we are truly grateful for her patronage and we hope that she will definitely recommend others as well.
Yeah. And having had Faustina come up with this appreciation, I want to also welcome on board and appreciate the people who have joined us live on Facebook and YouTube for your time. So let me, with your permission, Lawyer Eunice, let me quickly acknowledge some of the people who have joined us. So they also feel very important because BWM Solicitors is going to give us something so substantially good this afternoon as well. So we start off with this one from, let's see who is here. Let me pick it up from the platform. I know definitely Adai Safo, Tilly Duma, Nana Jimai, and all the wonderful people will be coming on board. If you come on board, what I would ask you to do, I said so. If you come on board when you are here with us, please like the page and the program and click on the notification button. Somebody will say, click on that small bell. And then we will obviously let you have any updates we have. And whenever there is a program coming your way, we'll notify you as well. So those of you who have joined us, thank you so very much. I so very much appreciate you. And I believe that you stay with us for the 2 hours in front of us to help one, educate ourselves, empower ourselves, and also make sure we are on the right hand side of the law. Now, Linus, I know that a couple of things came up this week, and one of the things you made us aware of is the nugget, those bits of information that you want us to have every now and then. Those of you who are new to this program and to this platform, what BWF Solicitor, sorry, BWF Solicitors does is that every Monday they drop some bit of information that will help us empower ourselves and also keep up to date with the law. Now we're talking about DBS. Now there are certain, I know Laura will explain that a bit more, but there are certain jobs where you apply and they say they require DBS. What is that? The full is the disclosure and barring service, and it has statutory powers to investigate safeguarding concerns and place individuals on barred lists, preventing them from working in regulated activities with children or vulnerable adults. The DBS operates independently to assess future risk, often issuing a minded to bar letter allowing 8 weeks for representations before a final decision. Before placing an individual on the bad list, the person, according to the regulation, must be given an opportunity to make a representation, so to speak, or make a representation action. This is to make the barring process fair and just. Um, we often quote from courses, and when we have done that, it is that we gave you the source. And this is from Safeguarding Vulnerable Groups Act of 2006. Like as well, I have babbled on, and from the ordinary person's point of view, from just speaking English point of view, I've done my bit. What does the law say specifically on this one?
Okay, so I think the thing that I have to mention about the disclosure and barring service is that they actually have the role of, should I say, checking those who are working within, for instance, um, the education sector or with children in general, or those working with vulnerable people. It could be within a care home, it could be within a hospital, and the rest of it. And so they make sure that these individuals who are working with vulnerable people and children are not a danger or are not going to cause them any harm. And so if they do feel that whilst the person is working within the sector, a complaint has been made, for instance, and they have to look at the complaint critically and assess whether whatever has been claimed is true, then they will go on to bar that person from working within that sector. There are three main ways that
It looks like we have lost the sound there, coming from Lawyer Eunice. Lawyer Eunice, can you hear me? Has it come back? No, the sound is gone again. Well, Linus was opening up the disclosure and barring service and the kind of powers it has, and was also letting us in on which kind of jobs and professions that really require this. And if you read the nugget as we have put on the screen, it says it has statutory powers to investigate safeguarding concerns and place individuals on bar lists, preventing them from working in regulated activities with children or vulnerable adults. Let's see if we can have Lawyer Eunice back with us with a sound.
I hope you can hear me now.
I can hear you
Oh,
now.
sorry about
Fantastic.
that. Yes, so I was explaining that there are three main ways in which they have these checks done. Usually, they can have the basic check. Most employers, if they do want to know if the individual working with them has no convictions or they have no risk of harm to the clients that they will be working with, they will do a basic check with the DBS service just to find out if they've had any convictions or if there are any cautions or warnings that they should be aware of. So that's a basic check. And then they have the standard check, where they would usually expect people like security men and the rest to convictions that have been spent that will come up on their DBS check, and any cautions, warnings, and the rest of it will also come up on that DBS check. And then the last but not the least is the hands check, where they would usually use on those within the children and vulnerable people sector. A lot of the care workers that we know would have an enhanced check. Those that work with children, like childminders, teachers, and the rest of it, will have an enhanced check as well. And so this will bring up anything in their past history, any criminal convictions, those warnings, like I said, whether they have been charged before, even if they haven't been convicted, any charges that have been brought against them, and the rest of it. So there are three main ways in which the barring disclosure and barring service carry out these checks, and then they make sure that the employer has all that is needed to be able to make sure that the employee that they are taking on obviously is right for the job and can competently administer their role.
Well, so if for instance I have been on the list, or when I am put on the list, I have something against me with dates back up to about 6 years or 10 years, would that still prevent me from working with vulnerable people? I may have spent the conviction or the charge one way or the other. Like,
Mm. I think that's up to the employer's discretion. Obviously, if the employer can see that that has been spent, would have to decide whether you are still right for the job. And so, with every employer, there's a discretion they have to obviously employ when they are looking at somebody who's been previously convicted, or let's say you've had a driving offense and the 3 years has passed, and you are thinking, okay, this shouldn't be much of an issue. I mean, an employer, if it was just a driving offense, they would not look so much into the driving offense unless it's something that is common, it's something that you do consistently. That's when obviously it will draw their attention to the fact that maybe this person may not necessarily be the right person for the job. So it's up to the employer's discretion.
well, and if I'm put on the list, how long can I stay on it? Can I get something done? So probably they will remove me earlier and quicker so I can get some job to do.
So when it comes to the barrenness, usually, like I said, even if it has been spent, when you're doing a standard or an enhanced check, it will be on there. And so even if you believe that it has been spent, um, with the enhanced check, it will always come up. Obviously, um, you wouldn't want somebody to not take you on the job just because maybe, for instance, one time you went over the speed limit and then they said you had to pay a fine or you had to get some penalty points on the rest of it. Um, with those ones, like I said, because it's an enhanced check, it will always be there to show that this is what has happened previously, and then this is what your current situation is. Maybe it happened 6 years ago. The employer will look at it and say, "Well, it happened 6 years ago. You haven't really committed any offense since that, and so that shouldn't be an issue." Where, for instance, somebody has committed it consistently, like I was saying before, then that might be an issue. But you may not be able to get yourself off the list unless at the stage where the employer was obviously investigating whether the claim that was put through against you was right. You went through an appeals process and you said, no, it's not true. I don't believe ABCD is true. And in that process, obviously, the police can get involved and they will come and question and interview you as well to find out if the supposed claim is as true as they say it is. And if they believe that you are guilty of what they say you did, then obviously that will go on your record. During the appeal stage, it's always good to have evidence to back whatever you are saying in order that you are not put on the list in the first place. So, yes, it's something that you have to try and manage before it gets onto the list.
Well, as lawyer has been explaining, the DBS service has statutory powers to investigate safeguarding concerns and place individuals on the bad list, preventing them from working in regulated activities with children or vulnerable adults. The good thing is that when they would want to put you on that list, they give you the chance up to 8 weeks, as the text is saying, for representation before a final decision. And when it's put on there, you may have spent it, but it would be at the discretion of the employer to look to pick you up or not. Well, thank you very much, Alex Osei. You have joined us, Eddie K, you have joined us, and those who have joined us as well, thank you so very much. As you may have heard and seen, EUSS Achampon, a partner of BWF Solicitors, is with us as a resource person and guest this afternoon on the community and the law. Okay, so having had this nugget explained, let's see what our answers will be to the scenario. Let me get you into it. On the 11th of May 2025, Caring Point Limited dismissed Said from work on the basis that he failed to challenge a colleague from abusing a service user. The employer also alleged that Said has received the necessary training and so should have been able to prevent the abuse from happening. The employer then reported the matter to the DBS for action. Said is troubled and so confused in his mind that he will be barred from working as a carer. So I'm asking you to help me advise Said. Are we going to say that as Said failed to prevent the abuse, he'll be placed on the barring list if he does not give reasons why he should not be barred? Are you going to say to him, Said should wait for a minded to bar letter from the DBS? Or are we going to say Said should give detailed response to the allegations stating why he should not be barred? Or can we also say that, okay, Said, we can do 1, 2, 3 all together. Think about it. I'm not going to ask you, you need to come in now because that would be feeding us and not allowing us to work. So I would ask you to look through it, think about it in line with the nugget where the DB system and the minding to bar and also reporting and the rest of it. What we said was that the Disclosure and Barring Service has statutory powers to investigate safeguarding consent and place individuals on bad lists, preventing them from working in regulated activities with children or vulnerable adults, thus operates independently to assess future risk, often issuing a minded to bar letter allowing 8 weeks for representations before a final decision. We're taking a quick break and when we come back, we will be looking at our topic for the day. Is it possible to apply for a settlement if you can show residence for 2.5 years out of the 5 years based on EUSS updates? We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And welcome back, and thank you for sticking around with us. We're live on BWTV, and the program is The Community and the Law, brought to you by BWF Solicitors. They're located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. Call them on 0208 493 7340, 0208 493 7340. If you're in Ghana, there's an office in Ghana, and you can reach us on 055 589 5959. I say that number again, sorry. 055 589 5959. And in all situations, in all emergency situations, call the UK number 077 127 61884. 077 127 61884. BWF Solicitors is a trusted partner when it comes to the law. Well, this afternoon, as I mentioned, we're going to look at some EUSS situation. 2.5 years, 5 years. The EUSS thing, does it still exist? Can people even put in applications under that, or whatever it is? We have one of the partners of BWF Solicitors, Eunice Champon, who is our resource person and guest this afternoon. Eunice, thank you very much and welcome again.
Thank you so much, Kweku.
Yes. Before I go to the question, I know somebody will say, well, it will be a yes or no answer, but there will be some details. But earlier on, there was this update that I chanced on, and maybe it would be right to ask about it now. that people who are dual nationals would have to obtain certain things before they can travel outside of the UK, and if you don't have certain things, you can't travel back to the UK and the rest of it. It's causing a lot of confusion in the community. What's happening?
So I think most people may have received an update email from the .gov.uk, should I say, updates team. So they have critically looked at those that are traveling and have said, do you know what? If you have a British passport or you have a certificate of entitlement to a right of abode, they believe that it's necessary for you to be able to now um, carry along that certificate of entitlement and your British passport. So where we have in the UK the possibility that somebody may have dual nationality, it is important that that person obviously will carry passports for both countries, and that would mean that they would have to travel with their Ghanaian passport, for instance, if they are going to Ghana, and then when they're returning to the UK, they carry their British passport where the person obviously has a certificate of entitlement. That means they have only a Ghanaian passport. And so it's important that when they're coming back, they will show that certificate of entitlement to a right of abode when returning to the UK, because it is that status that allows them to re enter the UK without having to go through so much of an immigration check. Just like Ghanaian nationals with limited leave to remain or indefinite leave to remain would need to show their e-visa or what people commonly call share code. The person who has a certificate of entitlement to a right of abode will also need to show that certificate readily when they are returning to the UK after their visit. And so it's key or it's important that that is available for them to make their checks. I know some people have expired passports, and so they're not sure whether they need to carry the one that has the certificate of entitlement. Yes, at all times, carry your current passport and the passport that shows that you have that certificate of entitlement to the right of abode, so that they are aware that you still have that certificate available. If you have by any chance obviously upgraded by naturalizing and you've been able to get a British passport, or you've applied automatically, because those with certificates of entitlement to right of abode can immediately apply for a British passport, then you can go ahead and show that since you were given a right of abode, you have now applied for a British passport, and therefore you are traveling with your British passport instead. And so they want the general public to know that yes, if you hold a British passport, do travel with that and your other passport if you're a dual national. And if you do have a certificate of entitlement to the right of abode, then you should have that certificate readily available as well.
My question on the certificate of entitlement, I understand it's a vignette that is put in the passport. In this age of technology and digitalization, can they kind of put it online, or like we do the share code, generate something, or maybe a card that would be carried along with our passport rather than carrying the new passport and the old passport? Probably my passport, I've renewed it like two or three times, and I'll be packing them back to back and all the rest of it. It's a bit of an inconvenience. Have they thought of that?
I mean, when it comes to a certificate of entitlement, like you said, it is a vignette within the passport. And so you may have to carry the old passport and the new passport. The only thing is that those who have a right of abode can easily apply for a British passport. And so I think the emphasis is on them to apply for a British passport so that they don't have to be carrying the old passport with the new passport the way I was explaining before, because if you don't show your certificate of entitlement to the right of abode and your current passport, it becomes difficult for the immigration officer to know if you truly have a right to re-enter the UK. And so it means that if you do have that certificate, then you should be able to apply for a British passport as soon as possible to alleviate you carrying two or three or four passports at a go when traveling.
Okay. Well, so that clears up the situation. So if you have, or you are a dual national and you have your nationality outside of the UK, like for instance, as Eunice explained, if you're a Ghanaian and a British national as well, you would want to travel with your Ghanaian passport to Ghana and come back to the UK with your UK passport. But if it does happen that you have only one passport and you have a certificate of entitlement, then obviously you need to show at the border of entry that you have the right to enter the UK. But then, Lainez, would I be right to advise people that if you have the certificate of entitlement, why don't you proceed to get a British passport? Why are they still keeping those ones in their passports?
Yes, I think for some people, I remember one person said to me, well, I don't think that I will need it at this point in time. And so I'm somebody who is constantly traveling. I don't think it's necessary for me to get the British passport. I was like, okay, fair enough. So everyone has their reason for not applying for the British passport. And it's for different reasons, and you can't really force anybody to apply for a British passport. But most people would naturally apply for a British passport if they have a certificate of entitlement to the right of abode, because they know that they are British citizens automatically, and therefore they can apply for a British passport. So most people will go ahead and do so. It's just a few that would obviously hold on to the certificate of entitlement before they apply for a British passport. So yes, it's advisable to let people know that they can apply for a British passport right away rather than holding on to the Ghanaian passport only. Yeah.
Okay. Well, a word to the wise is always enough, and I would want to say that if you need any further clarification on this or you want some advice concerning this one, you can readily contact BWF Solicitors located on the fourth floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters. Call them on 0208 493 7340 0208 493 7340, or in emergency and all other situations you can call 077 127 61884 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Another question is it possible to apply for settlement if you can definitely show that you have resided in the UK for 2.5 years out of the 5 years based on EUSS update? That's a question. I would say yes. Somebody would say no. I think I would say again maybe so. So we throw it up to you, Lawyer Eunice. Can we do that?
So the answer is yes to an extent, because a lot of people have it in mind that I don't have to have lived here for 5 years. I can just show I've lived here for 2.5 years, and I can go on and apply. And I think that's the wrong should I say, mindset towards this question. We should have it in mind that the EUSS team is trying as much as possible to make sure that those who have lived here for a 5 years continuous period can go ahead and apply for settled status. And you would see from the EUSS updates that they've been sending to people's emails that they have stated as much as possible they would try and automatically extend the leave of those whose 5 years is showing that they have obviously resided here for that period of time. If for any reason you believe that your 5 years is up, but they haven't contacted you or they haven't sent you any email to say that they are granting you an extension or they are granting you settled status straight away because they've realized that you've lived here for a 5 year continuous period, then of course it will be up to you to make that application, and then they would look at the evidence that you have provided to grant you your settled status. So it is still required that you have lived here for that 5 years continuous period, but there are some exemptions for those who have lived here for that 5 year period but cannot show the full 5 years, but they can show for 2.5 years.
I have somebody who sent me a copy of their letter. I'm going to take away the name, but I think there's a general thing that's down there. And it says that you are receiving this email notification because your pre settled status held under the EU settlement scheme has been extended, and because you may now be eligible for settled status as described below. You can't disregard this letter. That's a caveat they've put in there. And there is no need to contact us if you have already been granted settled status under the EUSS or become a British citizen. Then it continues in the next paragraph. It says, I am writing to inform you that your EU settlement scheme limited leave to remain in the UK under paragraph EU3 of Appendix EU to the immigration rules has been extended by 5 years. This is referred to as your pre-settled status. Your pre-settled status now is valid until then it gives a period, which is about 2030 from this time. This means you continue to have an immigration status under UK law. To maintain your status, you must continue to meet the EU settlement scheme eligibility conditions as set out in your original pre-settled status grant letter and repeated in the important information section of the at the end of this letter, which goes on to say all those things. If somebody receives a letter, an email like this, is this the one we are talking about, lawyer?
Yes, so this is a typical email that you would have received if you have pre-settled status or what we call limited leave to remain under the EU settlement scheme, which we commonly refer to as EUSS. So if you have pre-settled status, you would receive an email such as this just to let you know that we've realized that your 5 years is up. We are giving you an extension for a further 5 years, like you said, and it is up to you to make sure that you meet the requirements to apply for settled status. So them granting you a further 5 years is not your settled status. It is just an extension so that obviously if you want to put in a settled status application or what we commonly call an indefinite leave to remain application, you do so during that time before the 5 years they've granted you is up again. So it is the prerogative of the person who is a family member of an EU national or the EU national themselves to make that settled status application once they receive this extension. This is not a settled status in itself. So if you don't make the settled status application, then when the 5 years is up, it will be you that will have to go ahead and explain why you didn't make the settled status application when your time was up.
Okay. All right. So back to our topic and the question. So
Yeah.
if we have received this email from the Home
Yeah.
Office, and then I would want to reduce the 5 years to 2.5 years because I want to prove that. How do I do it, if at all is possible?
Mm. So it's necessary for us to understand the concept behind the settled status application.
Okay.
Anyone who has pre-settled status will understand from previous years that even when you had to make a permanent residence application, you needed to show that you have lived here for a continuous period of 5 years, as a qualified EU national. Now,
Okay.
the EU settlement scheme has made things a lot easier. You just need to show residence. You don't even need to show that you have worked here, or that you're a job seeker, or that you had comprehensive sickness insurance because you were a student. It takes all of those things away, and it only requires that you can show under EU 11 or EU 11A that you have resided in the UK for a continuous period of 5 years. The law hasn't changed, it's still the same. And usually people will say, oh, but the update said, oh, you can apply after 2.5 years. And so a typical one is like the one I sent to our producer, where it categorically states that you may still make an application after a 5 year period if you can show evidence of 2.5 years. Um, and yes, so this bit where it says changes to settled status residence requirements. So it says that the Home Office has simplified the residence requirements that pre-settled status holders must meet to obtain settled status. And that is what I was referring to as indefinite leave to remain. You can now qualify for settled status if you have pre-settled status and have been resident in the UK for at least 30 months, which is 2.5 years, in the 5 years before you apply for settled status, and you arrived in the UK at least 5 years ago. So we have to pay attention to the "and", because it's not just you showing requirement for the 2.5 years, but you also have to show that you arrived in the UK at least 5 years ago. And what they mean by you have arrived in the UK at least 5 years ago, it means that you have to show that you were a family member of an EU national 5 years ago, and you were granted pre-settled status, as they have said at the beginning. So if for any reason you are able to show that you arrived 5 years ago as an EU family member, or you are as an EU national, and you have been granted pre-settled status, it doesn't necessarily mean that the pre-settled status should have been for that 5 years continuous period, because there are some people who used to have a residence card before they obtained pre-settled status. And so you can't say that because the scheme has changed, the residence requirements for them will also change. They would automatically be eligible for settled status as long as they can show that they have been a family member of an EU national for that 5 year period. And in this case, it states categorically that you must show at least 30 months, which is 2.5 years, in the 5 years before you apply. So they must see that you have been in the UK as a family member of an EU national for a 5 year period, but you must be able to show 30 months or 2.5 years residence in the UK. And then if you look further down, it says that another important information, you don't need to explain any time spent outside the UK as long as she meets the new 30-month rule. Any applications not yet decided will be assessed against this new rule. So the reason why they say this new rule is because they have a new guidance that states that if you have any reasons why, for instance, you were out of the country for a period of 6 months outside of the 12-month period that they usually allow, then you can give them those reasons, and then they can have a look at that and then grant you your settled status. So in their new guidance, it's not under the immigration rules. I need to state that categorically so that people don't think that it's under the immigration rules. It is under their new guidance. So their new guidance states that you may be eligible. So may is always at the discretion. It is not something that they are obligated to grant, if I can put it that way. And so once you've been able to show that you have resided here for a continuous period of 5 years, however, within the 5 year period, there are gaps. There are, should I say, periods of absences that may not be explained in terms of why you were not here, but you are still here as a family member of an EU national, or you are here as an EU national yourself. If you are able to show that, yes, since the transition date of 31st December 2020, you have resided here, and at some point, maybe you were absent due to reasons beyond your control. Maybe it was because you were studying outside the UK. Maybe it was because a family member was ill. It could have been because there were issues that you had to handle at home because of family members. And so it meant that you had to take care of those issues before coming back. As long as you are able to show that you have at least resided in the UK for that 2.5 year period, within the 5 year period that they are expecting to see that you have clearly resided in the UK, then they can have a look at the evidence that you have brought forward, and then look at it critically, and then use their discretion to say that, oh yes, we can see that you have resided here for a 2.5 year period within the 5 years, due to reasons beyond your control because of A, B, C, D. And we believe that you are still a family member of that EU national. We can go ahead and grant you your settled status as you have applied for. And like I said, you will need to provide some sort of evidence, because they wouldn't just go ahead and say, oh yeah, you've lived here from, let's say, June 2020 to January 2026. If, for instance, you were not working in 2021 and you were not working in 2020, the evidence they will have will only be for 4 years. So then how would they know that you've resided here for 5 years unless you show them that you have resided here? They may not be able to automatically pick it up from the HMRC records. And there are some people who may have been on maternity looking after children, for instance. And so the only evidence they have of their residence will be letters that have come through the house. And so if they've been on maternity and they've been looking after children, then there might be gaps in between, because they may not have necessarily worked for that whole 5 year period. And so it becomes critical that they are able to show evidence of their residence whilst being at home and taking care of the children, let's say. So, yes, there are many examples of why somebody may not be able to necessarily have it on record that they've resided here for that full 5-year period, but they expect that you be able to provide evidence that yes, you have resided here for 5 years, but you are only able to show evidence of the 2.5-year period because A, B, C, D happened, and therefore you were not able to prove that you have lived here for the full 5-year period. So it's important that as much as possible.
Let me quickly
Sorry.
put in this question, if you don't mind.
Yes, yes,
Let's
please.
say a child, um, at the time of being given the pre-settled status, was under 18, or say 10-year old, and within that period they would have grown to become like 15, 16 years. In that case, what kind of evidence would the home office require so to prove that they have been living here for at least 2.5 years?
So this is a typical example of somebody who would have been considered to be a child at that pre-settled status stage. Once they've obviously clocked that 5 years continuous period, they are now over the age of 18, and they are trying to show that, oh yes, I was living here. Some would be able to go back to their schools to take evidence such as their school records to show that yes, they've been living here for that 5-year period. Some may not necessarily be able to do so because maybe they have been in care homes, or they have been under should I say, the government's hand, where they haven't been able to go to school, they have been absconded, and so there's no evidence to track exactly where they've been. And if that is the case, then it becomes important for um, the government to then say, hey, this child, they don't even have a passport, or even if they have a passport, there's no evidence that they've ever traveled. And so it becomes important for them to now go ahead and say, yes, we can see that you've been under this care home supervision, or you've been under social workers and the rest of it. And so we're going to go ahead and grant you your settled status anyway, even if there isn't continuous records on schools database and the rest of it to show that you've been living here. We can see that there's no way that you would have traveled outside the UK, and so we would grant you your settled status or your indefinite leave to remain. And so, yes, there are examples such as that, and it becomes important that the EUSS team are able to grant, even if they are not able to get a full record of the 5 years from that particular child or young adult.
So this team, from what you're saying, it looks like they keep looking into those applications that were granted under the USS. Could it be that they will, out of the blue, apply or send an email to a person to say that we realize that you qualify for settled status, so we granted it automatically because we expect that you would have satisfied the conditions? Can that happen?
I think they did say that they would introduce the settled status automatically for those who they can see from their records have resided here continuously for a 5-year period. Apart from the extensions that they have given out to people automatically, um I'm yet to see one where they've granted the person settled status automatically. And I believe that that is possible because they are able to link their data with HMRC. And so, for instance, where a person has continuously worked in the UK for a 5-year period, it is very easy for them to grant that person um, settled status or indefinite leave to remain because the evidence is clear. The evidence of their NI records show that, yes, indeed, they've been here, they've been working for a 5-year period. So we will go ahead and grant them settled status anyway because the evidence shows that this is what it is. I think that apart from using the NI number, it will be very difficult for them to grant somebody a settled status, especially if they haven't got that 5-year record. Yeah.
Well, I'm looking at a situation, maybe following up on the question that I posed. This young person at the age of 15, 16 is automatically giving an NI number. Would they then look at it and say, this person has been here since age 10, for instance, and was granted pre-settled since age 10. Now we have even gone ahead to grant this person an NI number because they have qualified or they are eligible for an NI number. Would that be evidence enough?
I mean, granting somebody an NI number is only evidence that they can now work or their employer can pay taxes on their behalf.
Mhm.
And so that in itself is not evidence enough because it will only show that they've been granted a reference for HMRC for their employer to use when paying their taxes. But if, like I was saying, the child has resided here for that continuous period of 5 years, they can obviously have their supervised person, their guardian, their parent apply on their behalf and
Okay.
show by way of school letter or GP letter or records from different institutions that they have resided here for that 5-year period. And once they have it readily available, that they can see that for each year there is something to show that they've lived in the UK, then they can grant them the settled status as soon as possible. But where you're only relying on an N9 letter, that in itself may not necessarily show that they've even lived here for that 2.5-year period. So they will need more evidence to be able to go on and grant them settled status rather than just the NI letter.
Well, if you just joined us, you're live with us on BWTV, and we're bringing you the community and the law. And it's brought to you by BWF Solicitors. We're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. What we're looking at this afternoon is the question: is it possible to apply for settlement if you can show residence for 2.5 years out of the 5 years that you had based on the EUSS extension and update? Ryan is a partner of BWF Solicitors, is a resource person and guest. You can send in your comments, your questions, and all the other bits that you use to help us get this program running on our text and WhatsApp number 07399 208 468 07399 208 468. Or you can put them in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. So let me just quickly run you through what our social media handles are. And when we come back, we would have further questions and also to pick up your questions and comments from the comment section down below or from social media platforms other than Facebook and YouTube, and on our text and WhatsApp message as WhatsApp message phone as well. Stick and stay. We'll be right back. Well, welcome back and thank you for sticking and staying. Thank you for your contribution. Now, if you have stayed with us up until this time, you deserve a praise. And if you just joined us, we also want to say that like the page, share the link, and also let's see what comments you have. If you would want to put that through our text message and WhatsApp phone, the number is 07399 208 468. 07399 208 468. I mentioned earlier that our resource person and guest this afternoon is a partner of BWF Solicitors, lawyer Eunice Echampo. I think it is. I'm coming back to the question. I think we have something on the platform that I've just put on. There's a part of a letter that somebody's put on and says, Home Office was written to say, our records show that you were granted pre-settled status almost 5 years ago. If you have continued to meet the pre-settled status requirements since it was granted, including the requirement to maintain continuous residence, we may be able to convert your pre-settled status to settled status. We will contact you again to let you know when we attempt to do so. And the question the person is asking is, what does this mean?
Yes. So, yes, there are those who have received such emails, and like this person has rightly put on, when it comes to the Home Office being able to grant you settled status, they need the evidence readily available. And so, if they haven't got evidence from your NI that you have resided here for that 5 year period, unfortunately they cannot grant you settled status automatically. And so that is why they say we will attempt to do so. Once they are able to do so, then they will contact the person again. But if you believe that you have resided here for that continuous period of 5 years and you have the evidence to prove that you have resided here for that 5 year period, why not make the application for settled status anyway?
Mm.
And there is a point where they say if you do believe that you meet the requirements for settled status, you can go ahead and make the application. So it's a free application. There's nothing very stringent about it. You can go ahead and make the application for settled status, and they will always require your pre-settled status reference number anyway when you're making the settled status application. And they will ask you the things that they would usually ask even when you made your pre-settled status application. Have you been here pre uh, December 2020? Were you resident in the UK? Did you make your pre-settled status application before June of 2021? Are you a family member of an EU national? If you are currently not a family member of an EU national, are you going to make the application on a retained right basis? Even if you're making the application on a retained right basis, how were you related to the EU national? How long have you resided in the UK? Do you have the details of the EU national? Do you have their unique application number? So they will ask you all of these relevant questions in order to ascertain that you are somebody who obviously had pre-settled status because you were eligible as a family member of an EU national. And now that you have shown continuous residence over a 5 year period, you will be eligible for settlement once you have provided evidence. So like Rafin Pon said, when it comes to a statement like that, if they don't have the evidence to show that you've resided here for a continuous period of 5 years, they'll wait till they can see evidence before they grant you that settled status.
So then, when they have written to you to say they have extended it for another 5 years, Then you have 5 years to build that evidence. And once you get it, even if it's a day after the email, you can put in the application, isn't it?
Definitely, definitely. And I think that you shouldn't wait for the 5 years extension to be up before you apply for settled status. Once you know your 5 years is up, make the application anyway.
All right. And but if for instance you have a few months to the 5 years and they send you an email like this, would you be still eligible to put in the application to say, I've lived here for more than 2.5 years, so I think I qualify?
I mean, in a case where you have a few months close to the 5 years, I always say that it depends on how you are calculating it. If you are calculating it based on when you were granted pre-settled status, then it means that you may have already gone past your 5 year period, because we know from the withdrawal agreement and also from previous EU regulations that when it comes to EU nationals and their family members, immediately that you are able to show that you're a family member of an EU national, you have that right of residence. So your right of residence is derived from being a family member of that EU national, or from being an EU national who has arrived in a member state. And if for any reason the UK is no longer part of the EU, those principles are still embedded under the withdrawal agreement. And therefore, if you are able to show that, yes, I was a spouse of this EU national from, let's say, 2019 up to now, then it means that your right of residence began in 2019 and not when you were granted pre-settled status. And so your 5 years would have been up, let's say, sometime in 2024. And if you can show evidence from 2019 to even 2025 that you've resided here as a family member as of an EU national, then you can go ahead and put in the application. If you are calculating from when you were granted pre-settled status and you think your pre-settled status is based on you being an extended family member, for instance, then of course, usually with extended family members, your 5 years residence will start from when you were granted pre-settled status. So if you're granted pre-settled status, say sometime in 2021, then it means that you'll be eligible for your settled status sometime in 2026. And so, as long as you can provide evidence of your residence here in the UK, you can go ahead and make the application. And usually, they expect that you can show the full 5 years. So, if your 5 years is not up, just wait till the 5 years is up before you make the application.
Well, I know you will also have questions, so I invite you to drop them in now. Text message, WhatsApp 07399208468, or send them into the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Kwaku July says, I currently hold a partner visa under the Appendix FM. I'm planning to travel outside UK between the 5th of June 2026 and coming back the 30th of August 2026. Would that affect me when I apply for my indefinite leave to remain?
Okay, so I think he's probably heard that if he is absent for a certain period of time, it might affect his settled status or his indefinite leave to remain application. Usually, we know that under appendix continuous residence, you shouldn't be absent from the UK for at least a period of 6 months within a 12-month period. So, if you haven't been absent for 6 months within a 12-month period, then you should be fine, Mr. Kweku July. It's only 2 months or less than 2 months within the year, so that shouldn't affect your application for indefinite leave to remain at all.
Well, Kwaku July, thank you very much. Yes, keep yours coming 0739920848. If you want to call, Lawyer Ines is ready to pick up your call 0208 493 7345. 0208 493 7345. Or you send a text or WhatsApp 07399 208 468. Or keep it in the comment section down below as we have picked two from friends who have done that. The next one is from Nanette Chiahine, and Nana is saying that please, mother has British child from previous relationship with British citizen. Mother has 2.5 years leave. Mother now has a boyfriend and have second child with a boyfriend. Mother has 2.5 years to remain. I think you mentioned that already, haven't you? Father of second child has no leave and they all live together. They have lived for less than 2 years. Will this application be on parent or partner route as they are not married but living together for less than 2 years? Lawyer, a lot of calculations here.
I I always say that Aitia Hine is our pocket lawyer. He will always ask those questions where definitely you would need to be able to advise him on a practical level. So yes, when it comes to a boyfriend, or let's say a partner in this case, of somebody who has a British child, many a time we have explained what it is to make an application under Appendix FM of our immigration rules as a step parent. And I think last week we briefly touched on that when somebody asked the question about is it possible to make an application based on you being the step parent of the child? And it is possible if you are able to show that, yes, you are part of this child's life because you are a family unit. And the only way that you can be a step parent is if you are married to the parent. So
Mhm.
you can't say that you are playing a role in the British citizen's life and you are not really married to the mother of the child, or you're not married to the father of the child. It wouldn't make any sense. Nobody would truly believe that you are committed to playing an active role in that child's life. So if you are saying that you are playing an active role in the child's life because you are married to the child's mother or to the child's father, they will go ahead and first look at the requirements under the partner route. In this case, the partner is neither British or settled or has EUSS status. And so they wouldn't meet the requirements to make a valid application as a partner in the first place. But because obviously they are married to someone who has a British child, that makes them a parent who is able to show that they also have responsibility for this British child because they live with this child on a daily basis. They probably take the child to school and pick the child up. They probably take the child for extracurricular activities. They do other activities within the house with the child as well. So for the parent who is a step parent, it becomes a very, very responsible role for them to be able to say that, yes, even though I'm not the father of this child, I'm still playing an active role in this child's life. And as long as they are able to show that they are playing an active role and the mother is able to provide a supporting letter to show that these are the things you do for the child, then you can make the application on the basis that you are a step parent who is looking after a qualifying child. In this case, obviously, you will have to show evidence of that active role you are playing in the child's life, which may include letter from the school or the GP or from any institution where they carry out extracurricular activities with the child. And you would also need to be able to show that the other parent is very much in favor of you playing that role in that child's life. and the Home Office will always have a look at Gen 3.2, where they would look at whether it would be reasonable to let this child leave the UK if your application is refused, and if obviously it will be unduly harsh for them to refuse your application based on the reasons that they may have, then they would think twice about granting you leave or not granting you leave based on the considerations that they have made in regards to the child and their family unit, and you playing that active role in the child's life. So it's very, very important to show evidence they are playing an active role, and then the caseworker can have a look at the evidence and then also consider Gen 3.2 as well as Section 55 of the British Citizenship and Immigration Act, where they have to have the child's best interest at heart. Probably the child's father is not playing any role in the child's life, and this is the only father figure that the child has in their life. And so they will consider that as well.
Well, keep them coming through 0739920848. Put them in the comment section down below. We're picking them up. Lawyer Eunice Achampon is here. She's a partner of BWF Solicitors, and she's graciously allowed herself to be available for us to have the benefit of knowledge and experience. Is it true that they are calling mothers with British citizenship to come for interview?
I think this person is referring to the fact that if you're applying for British citizenship for your child, usually it's for passport applications. So I'm not going to generalize British citizenship in general. It's mostly for passport applications where, for instance, the mother or the father may both be called to an interview just because they want to be sure that the said father or the said mother is actually the parent of the child. We all know that when it comes to applying for British passport, usually if the person hasn't been naturalized or registered, the person is automatically British because one of their parents was settled in the UK or had British citizenship before the child was born. So if you are a child who is automatically British because your parent or one of your parent was British or settled before you were born, then you can apply for a British passport right away. So in the case where, for instance, you are applying for a British passport and it is not believed that you are the parent, they might invite you for an interview just to cover the gaps that they may have in their reasoning before they grant the child their British passport.
Keep them coming through. Somebody sent a very interesting text message, and I'm going to give a very straightforward answer, but listen, I'm not a lawyer, so I'll leave it. Can I be moving to the kingdom land for free money? Give me house, give me everything. The answer is no.
I mean, for this person to ask this question very boldly, I would like to say, when it comes to the United Kingdom, yes, they do have a public benefit system or a welfare state, as we call it. But I do not think that they are given to people just because people who are able to work are not working and they are sitting at home. If you are able to work, please go and work and fund yourself. Don't rely on the state for benefits or any kind of handouts because they do assess whether it is needed before they do give public funds. So please, if you are able to work and use both hands, you're not only working for yourself, but just look at it as you also having some satisfaction in life. You can't always be sitting around and waiting for handouts.
Keep them coming through. Mike, somebody say, be steady. Okay. 0739920848, or keep them in the comment section down below. Facebook and YouTube at BWF Solicitors and at BWTV. Is a graduate route dependent allowed to marry again in the UK after December 2025?
Okay, so marriage has nothing to do with your documentation unless you are saying you are going to get married because you want to be able to apply as a dependent of this person who is on the graduate route. So if that is the question, then usually I would say the graduate route still allows for somebody who has a dependent to be able to apply onto that route. So let's say the person made an application as a student, they've completed their course, and they have successfully shown the Home Office that they have completed their course. They can be granted 2 years on the graduate route. Let's bear in mind that from January next year, which is January 2027, this will be reduced from 2 years to 1.5 years. So anybody who will be making an application next year will have to bear in mind that they'll only be given 1.5 years. In relation to this question, if you were a dependent before the person was making the application on the graduate route, then of course the person can add you on if they were able to show that they came in as a student before the rules changed in 2024. So we all know that those who are students can no longer apply to bring their dependents because of the changes that came into effect in March 2024. But if the student came before March 2024 and is applying to the graduate route, they can apply with their new dependent onto the graduate route. However, if they have already applied to the graduate route, after which time they are saying that their new dependent also wants to apply to the graduate route, I mean, there's nothing in the immigration rules that will necessarily prevent this new dependent, unless they are saying that obviously this dependent doesn't meet the requirements under the immigration rules. And usually they will have to meet the relationship requirement and the maintenance requirement as well. So if they don't meet these requirements, then they can be refused.
Well, we still have some time on our hands. If you can keep them coming through, we'll pick that one up. Lawyer Ines will be on hand to help us answer them. When it comes to certificate of sponsorship, lawyer, Eva is asking, can my sponsor stop me from doing supplementary work?
I'm wondering why your sponsor will stop you from doing supplementary work. The rules allow for you to do an extra 20 hours elsewhere, where obviously we know that in the health and care sector there is a demand. So specifically in the health and care sector, you can apply to do some extra 20 hours with a different employer altogether, because obviously they may need that extra hands in terms of the clientele that they have. I don't see why an employer would stop you from working with another employer unless they're saying that you are not working for them at all. So if this main employer is saying, well, you haven't really done the hours you're supposed to be doing with us and you're going somewhere else, then that could be an issue.
So, Eva, that's your answer. Thank you very much for sticking around and sending it through. Let's see what else and who else we have. Remember, I gave you the nugget and the question. I'll be going back to it. Nana Kwame Akatapori Manso says, in cases one impregnates another woman whilst the dependent is not in the UK, can the newborn be put under the man's visa as their child?
I mean, when it comes to children, I always say that the law is always lenient with the children. So if the parent of this newborn child wants to apply for the child to be on their route, I don't know whether it's a skilled worker route or a student route. I'm not exactly sure what routes they are on, but if it's the skilled worker route, they should be able to apply for them to be on that route with them.
We'll take the very last one and go back to our nugget and also back to our scenario. Yawachiajiman is asking, please, further leave to remain renewal is with the Home Office, but I'm unable to create a share code with my application reference number. Is there a reason why? Well,
To tell you the truth, there are some people who previously were able to generate a share code, and for some reason they are unable to generate a share code. I always say that it could be an error on the .gov.uk website, because if it's something that you were previously able to do with the same identification and the same date of birth, and now it's telling you that you are not able to do so, then that means that there must be an error on their system, and you can report it as an error on the e-visa website. If, however, this is your first time trying to get a share code and it's not working because maybe the application number you've put through is not going through, or the identification document that you are using is not going through, then obviously see somebody else who is well versed in the system of accessing e-visa. Let them try and help you before you report it.
very good advice coming from BWF Solicitors. Remember, this program is brought to you by BWF Solicitors, our trusted partners when it comes to the law. Located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. Postcode N15 4NP. If you traveling by public transport, get on the underground Victoria line, get off at Seven Sisters, use exit number 2. That will take you to the frontage of the Anna House. Climb up to the fourth floor. You find BWF Solicitors. They are there Monday to Friday between 9:30 in the morning and 6 p.m. Call them on 0208 493 7340. The number again 0208 493 7340. In emergency situations, 077 127 61884. Now, earlier on, we talked about the DBS, which was our nugget for the week. And we said that the Disclosure and Barring Service has statutory powers to investigate safeguarding concerns and place individuals on barred lists, preventing them from working in regulated activities with children or vulnerable adults. The DBS operates independently to assess future risk, often issuing a minded to bar letter allowing 8 weeks for representations before a final decision. Now, before placing an individual on the barred list, the person must be given an opportunity to make a representation. This is to make the barring process fair and just. That was quoted from the Safeguarding Vulnerable Groups Act of 2006. Now, I have this friend who works in a care company, right? On the 11th of May 2025, Caring Point Limited dismissed Said from work on the basis that he failed to challenge a colleague from abusing a service user. The employer also alleged that Said had received the necessary training and so should have been able to prevent the abuse from happening. The employer then reported the matter to the Disclosure and Barring Service for action. Now, Said is worried and troubled because, listen, if you are put on that list, you can't work, especially in that sensitive area as a care home. So, let's see what advice we can give to Said. One would say, as Said fails to prevent the abuse, he will be placed on the barren list if he does not give reasons why he should not be barred. Or we can say Said should wait for a minded to bar letter from the DBS. And then we also give you the option to say Said should give detailed response to the allegations, stating why he should not be barred. Then finally, I give you a fourth option. We can do all the three above. So Said, wait, people are going to give you their responses. But in the meantime, let's say thank you to BWF Solicitors for allowing us to bring you this very educative and empowering program. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
BWF Solicitors, thank you so much. And those of you who have stuck with us and stayed up until this time, we want to say thank you so very much. So let's see what answers we have from the platform and from our WhatsApp message line. Prince Yabwa says, as Said failed to prevent the abuse, he will be placed on the barring list if he does not give reasons why he should not be. So says it's number one. Akosia says it's number four, all of the above. So 1, 2, 3, all advice that Said can follow. Mary Toto says, as Said failed to prevent the abuse, he will be placed on the barren list if he doesn't give any reasons why he should not be barred. Henry Amwath also thinks it's number one. Thank you, Henry. We go to the next one, Deborah Oduro. Deborah Oduro says it's number 3. Said should give detailed response to the allegations, stating why he should not be barred. What you're saying comes in with Said should wait for a minded to bar letter from the DBS. That's answer number 2. Emmanuel Che thinks that we could say that Said failed to present the abuse, he'll be placed on that. So he should give, if he does not give reasons, he'll be placed on the barren list. And 2 and 3 also apply. We come to Abeta Tete. Tetes thinks that is number three, Said should give detailed response to the allegations, stating why he should not be barred. Yao Banahine comes in with number two. Said should wait for a minded to bar letter from the DBS instead of worry. Elizabeth Aite also thinks that Said shouldn't worry, just wait for a minded to bar letter from the DBS. Kofi comes again and says, as Said failed to prevent the abuse, he will be placed on the list if he does not give reasons why he should not be barred. Janet Kubi also thinks it's number one. Well, keep it coming. Let's see how many more we get. Esther Saki thinks it's number three. He should give detailed response to the allegations and also state why he should not be barred. Kwesijima says is all of the above. 1, 2, and 3. Thank you, Kwesi. Yapia. Yapia says is number 3. You should give detailed response to the allegations, stating why it should not be barred. Jennifer Prempe thinks it's all the 3. He should he will be placed there if he doesn't give reasons. Or listen, wait for them to come up, and then you should give detailed response to the allegations, stating why you should not be barred. That's the advice we will give Said, as per the last person that came through. Okay. Now, before I go to lawyer, I know it will be a very good point referring to the nugget again. Then we see how we can put 1 and 2 together and give the right full advice to Said. The Disclosure and Barring Service has statutory powers to investigate safeguarding concerns and place individuals on bar lists, preventing them from working in regulated activities with children or vulnerable adults. The DBS operates independently to assess future risk, often using a minded to bar letter, allowing 8 weeks for representations before a final decision. Before placing an individual on the barred list, the person must be given an opportunity to make a representation. This is to make the barring process fair and just. So I'm going to be fair and just by asking lawyer to help me find what the best advice would be to be given to a friend Said. Lawyer.
Yes, so when you look at this question very critically, you would realize that Sahid himself did not commit the abuse, but he saw somebody committing the abuse and did nothing to prevent it. That should warn a lot of people that just because you did not carry out the abuse does not mean that you can stand aside and watch somebody do what is seen to be unlawful and then still say it wasn't you. Here, I don't think Said ever thought in his mind that he would be, should I say, punished in such a way, because to him, he didn't see it, and so he didn't say anything. But I'm sure his supervisors may have had cameras around in the workplace, realized that he was present when the abuse was taking place, and he didn't report it. And so if Said was smart enough, Said could have walked away as soon as he realized that there was something going on. Or he could have said, I think my colleague needs some help. Let me go and call my supervisor to come and deal with this situation. So it's very, very critical to not be stand by and think that you will not be held responsible. Even though he was standing aside, he was still held responsible for what went on. So we must be very, very critical when it comes to situations like this, so that we do not find ourselves wanting as well. So when it comes to whether Saeed can go ahead and obviously be barred from his working with the care company or any care company for that reason, the first answer says as Said failed to prevent the abuse, he will be placed on the barring list if he's not able to give reasons why he should not be barred. So he definitely needs to be able to give reasons why he should not be barred. Usually they will consider any mitigating circumstances that may arise. Maybe Said was with another resident and he could not have left that resident to pay attention to what his colleague was doing at the time and the rest of it. When it comes to answer 2, it says that Said should wait for a minded to bar letter from the DBS. It is a requirement by the Disclosure and Barring Service for them to send a notification that this person is minded to bar. And then, of course, you have the opportunity to also go through an appeals process with your employer when the case is ongoing. So if there is an appeal, please go ahead and take the appeal on and deal with it critically as well with the employer when the need arises. And when it comes to answer 3, it says that Said should give detailed response to the allegations, stating why he should not be barred. So yes, you will have to give detailed response why you should not be barred, and then they will have a look. The Disclosure and Barrier Service will have a look at the detailed reasons with evidence. So you can give your reasons with evidence, and then they would have a look at it to see why you should not be barred from working with children and vulnerable people as a result of what happened. And this is very critical because, like we said, Said was not the one that committed the abuse, but he was present when the abuse was taking place. So he must present all his reasons why he didn't report it when he saw the abuse taking place and why he didn't also prevent it from happening when it took place. So we'd say this week's answer is all of the above. I know why people chose those individual answers, but this week's answer is all of the above.
Well, the answer, the quiz, as lawyer has explained, is number 4. And she's gone on to explain that even though Said can be barred, the law requires that he must be informed about it and also given an opportunity to respond to the notice to bar him from working as a carer. Um, we've continued to give the explanation that he should wait for a letter from the DBS first. He should respond to the letter by explaining to the DBS with reasons why he should not be placed on the barring list. Well, if you want the source of this one, check the Safeguarding Vulnerable Groups Act of 2006. And with that, we come to the point where we go back to our question topic and get lawyer to give us a brief summary of what we have discussed. Lawyer Ines, back to you.
So yes, this week we looked at, is it possible for a person to apply for settled status after they have resided here for a period of 2.5 years out of the 5 years? We said it is yes to an extent if you are able to show that you have resided here for a 5-year period. However, you don't have consistent evidence that you have lived here for that 5-year period, but you can show that you've lived here for a continuous period of 2.5 years, then you should be able to provide reasons why obviously you were absent or reasons why your evidence is not tallying up with the 5 years of residence. The immigration rules under Appendix FM state that you should be able to show continuous residence of 5 years. However, the Home Office guidance also gives applicants Also, the right to apply for settled status if they are able to show that they have resided here for a period of 5 years. However, they may not be able to present evidence for the full 5 year period, but only for a 2.5 year period. And we gave examples of maybe a mother going on maternity and then looking after her children, or where a child has previously made an application and they are making the application after a 5 year period, but they may not necessarily have all the evidence to show that they have resided here for a 5 year period. And if that is the case, usually you may be able to present evidence that yes, uh, for that 2.5 year period, I was with a care home, and that is the only evidence I can present, or I was on maternity leave, I was taking my child for inoculations and other postnatal appointments, and I've subsequently stayed at home, I haven't worked. And so all of these evidence will go towards the reasons why you are not able to present maybe a full 5 years continuous residence. But at least if you are able to present the reasons why you were not able to show evidence of the full 5 years, it is up to the discretion of the caseworker to look at the evidence you have presented and then go ahead to see if they can grant you a full settled status. And if you are somebody who has worked within the UK for a 5 year period as a family member of an EU national, then you may be eligible for indefinite leave to remain or settled status under the EUSS or the EU settlement scheme.
Well, I believe that there may be some other questions bugging you. What we can ask you to do is to continuously contact BWF solicitors, because they always have their doors open and are prepared to help you go through this journey. Call them 0208 493 7340. Those of you in Ghana, 055 589 5959. Or in an emergency situation, call the UK number 077 127 61884. 077 127 61884. Now, all of you, join me to say thank you to lawyer Eunice Champon. Lawyer Eunice Champon is a partner of BWF Solicitors, and she has made time to be with us 2 hours on this program this Saturday afternoon. Lawyer Eunice, thank you, and thank you again. We believe that the joy you derive in helping the community will also keep that smile on our faces and give us the confidence to come to BWF Solicitors all the time when we have our legal needs and questions that will be bothering us. Thank you so very much. And to you out there, I want to say thank you so much for sticking and staying with us for 2 hours. I know it's been very exciting and you think that the 2 hours has flown by, but there's a lot and it means a lot to us. So thank you for your time and thank you for making the program as good as we intended to be. So on that note, I want to invite you to come join us same time next week when we come your way with another edition. My production team has been made up of Shilankre Padmododu for the admin and aesthetics, and Professor Ade for producing and directing from the studios. My name is Ulrike Frimpong. Have a good evening.